Section 1 of an examination into the leading principles of the Federal Constitution. This is a LibriVox recording. All LibriVox recordings are in the public domain. For more information or to volunteer, please visit LibriVox.org. Read by Janet Wedge. An examination into the leading principles of the Federal Constitution by Noah Webster. An examination into the leading principles of the Federal Constitution, etc. Of all the memorable eras that have marked the progress of men from the savage state to the refinements of luxury, that which has combined them into society under a wise system of government and given form to a nation has ever been recorded and celebrated as the most important. Legislators have ever been deemed the greatest benefactors of mankind, respected when living, and often deified after their death. Hence the fame of Phoebe and Confucius, of Moses, Solon, and Lycurgus, of Romulus and Numa, of Alfred, Peter the Great, and Mango Capac, whose names will be celebrated through all ages for framing and improving constitutions of government, which introduced order into society and secured the benefits of law to millions of the human race. The Western world now beholds an era important beyond conception, and which posterity will number with the age of Tsar of Muscovy and with the promulgation of the Jewish laws at Mount Sinai. The names of those men who have digested a system of constitutions for the American Empire will be enrolled with those of Zalmoxis and Odin, and celebrated by posterity with the honors which less enlightened nations have paid to the fabled demigods of antiquity. But the origin of the American Republic is distinguished by particular circumstances. Other nations have been driven together by fear and necessity. Their governments have generally been the result of a single man's observations, or the offspring of particular interests. In the formation of our Constitution, the wisdom of all ages is collected. The legislators of antiquity are consulted, as well as the opinions and interests of the millions who are concerned. In short, it is an empire of reason. In the formation of such a government, it is not only the right, but the indispensable duty of every citizen to examine the principles of it, to compare them with the principles of other governments, with a constant eye to our particular situation and circumstances, and thus endeavor to foresee the future operations of our own system and its effects upon human happiness. Convinced of this truth, I have no apology to offer for the following remarks, but an earnest desire to be useful to my country. In attending to the proposed federal constitution, the first thing that presents itself to our consideration is the division of the legislative into two branches. This article has so many advocates in America that it needs not any vindication. Footnote: a division of the legislature has been adopted in the new Constitution of every state except Pennsylvania and Georgia. But it has its opposers, among whom are some respectable characters, especially in Pennsylvania, for which reason I will state some of the arguments and facts which incline me to favor the proposed division. On the first view of men in society, we should suppose that no man would be bound by a law to which he had not given his consent. Such would be our first idea of political obligation, but experience from time immemorial has proved it to be impossible to unite the opinions of all the members of a community in every case, and hence the doctrine that the opinions of a majority must give law to the whole state, a doctrine as universally received as any intuitive truth. Another idea that naturally presents itself to our minds on a slight consideration of the subject is that in a perfect government, all the members of a society should be present, and each give his suffrage in acts of legislation by which he is to be bound. This is impracticable in all large states, and even were it not, it is very questionable whether it would be the best mode of legislation. It was, however, practiced in the free states of antiquity, and was the cause of innumerable evils. To avoid these evils, the moderns have invented the doctrine of representation, which seems to be the perfection of human government. Another idea, which is very natural, is that to complete the mode of legislation, all the representatives should be collected into one body for the purpose of debating questions and enacting laws. Speculation would suggest the idea and the desire of improving upon the systems of government in the old world would operate powerfully in its favor. But men are ever running into extremes. The passions, after a violent constraint, are apt to rush into licentiousness, and even the reason of men who have experienced evils from the defects of a government will sometimes coolly condemn the whole system. Every person moderately acquainted with human nature knows that public bodies, as well as individuals, are liable to the influence of sudden and violent passions, under the operation of which the voice of reason is silenced. Instances of such influence are not so frequent as in individuals, but its effects are extensive in proportion to the numbers that compose the public body. This fact suggests the expediency of dividing the powers of legislation between two bodies of men whose debates shall be separate and not dependent on each other, that if at any time one part should appear to be under any undue influence, either from passion, obstinacy, jealousy of particular men, attachment to a popular speaker, or other extraordinary causes, there might be a power in the legislature sufficient to check every pernicious measure. Even in a small republic composed of men equal in property and abilities, and all meeting for the purpose of making laws, like the old Romans in the field of Mars, a division of the body into two independent branches would be a necessary step to prevent the disorders which arise from the pride, irritability, and stubbornness of mankind. This will ever be the case while men possess passions easily inflamed, which may bias their reason and lead them to erroneous conclusions. Another consideration has weight. A single body of men may be led astray by one person of abilities and address who, on the first starting a proposition, may throw a plausible appearance on one side of the question and give a lead to the whole debate. To prevent any ill consequence from such a circumstance, a separate discussion before a different body of men and taken up on new grounds is a very eligible expedient. Besides, the design of a Senate is not merely to check the legislative assembly, but to collect wisdom and experience. In most of our constitutions, and particularly in the proposed federal system, greater age and a longer residence are required to qualify for the Senate than for the House of Representatives. This is a wise provision. The House of Representatives may be composed of new and unexperienced members, stranger to the forms of proceedings and the science of legislation, but either positive constitutions or customs which may supply their place fill the Senate with men venerable for age and respectability, experienced in the ways of men and in the art of governing, and who are not liable to the bias of passions that govern the young. If the Senate of Rhode Island is an exception to this observation, it is proof that the mass of people are corrupted, and that the Senate should be elected less frequently than the other House. Had the old Senate in Rhode Island held their seats for 3 years, had they not been chosen amidst a popular rage for paper money, the honor of that state would probably have been saved. The old Senate would have stopped the measure for a year or two, till the people could have had time to deliberate upon its consequences. I consider it as a capital excellence of the proposed Constitution that the Senate can be wholly renewed but once in 6 years. Experience is the best instructor. It is better than 1,000 theories. The history of every government on earth affords proof of the utility of different branches in a legislature, but I appeal only to our own experience in America. To what cause can we ascribe the absurd measures of Congress in times past and the speedy rescission of those measures, but to the want of some check? I feel the most profound deference for that honorable body, and perfect respect for their opinions, but some of their steps betray a great want of consideration, a defect which perhaps nothing can remedy but a division of their deliberations. I will instance only their resolution to build a federal town. When we were involved in a debt of which we could hardly pay the interest, and when Congress could not command a shilling, the very proposition was extremely absurd. Congress themselves became ashamed of the resolution and rescinded it with as much silence as possible. Many other acts of that body are equally reprehensible, but respect forbids me to mention them. Several states since the war have experienced the necessity of a division of the legislature. Maryland was saved from a most pernicious measure by her Senate. A rage for paper money, bordering on madness, prevailed in their House of Delegates, and emission of 500,000 shillings was proposed, a sum equal to the circulating medium of the state. Had the sum been emitted, every shilling of specie would have been driven from circulation, and most of it from the state. Such a loss would not have been repaired in 7 years, not to mention the whole catalogue of frauds which would have followed the measure. The Senate, like honest, judicious men and the protectors of the interests of the state, firmly resisted the rage and gave the people time to cool and to think. Their resistance was effectual. The people acquiesced, and the honor and interest of the state were secured. The House of Representatives in Connecticut, soon after the war, had taken offense at a certain act of Congress. The upper house, who understood the necessity and expediency of the measure better than the people, refused to concur in a remonstrance to Congress. Several other circumstances gave umbrage to the lower house, and to weaken or destroy the influence of the Senate, the representatives, among other violent proceedings, resolved not merely to remove the seat of government, but to make every county town in the state the seat of government by rotation. This foolish resolution would have disgraced schoolboys. The Senate saved the honor of the state by rejecting it with disdain, and within 2 months every representative was ashamed of the conduct of the House. All public bodies have these fits of passion when their conduct seems to be perfectly boyish, and in these paroxysms a check is highly necessary. End of section 1.
Section 2 of an examination into the leading principles of the federal Constitution. This is a LibriVox recording. All LibriVox recordings are in the public domain. For more information or to volunteer, please visit LibriVox.org. Read by Claire. An examination into the leading principles of the federal Constitution by Noah Webster. Section 2. Pennsylvania exhibits many instances of this hasty conduct. At one session of the legislature, an armed force is ordered by a precipitate resolution to expel the settlers at Wyoming from their possessions. At a succeeding session, the same people are confirmed in their possessions. At one session, a charter is wrested from a corporation, at another restored. The whole state is split into parties. Everything is decided by party. Any proposition from one side of the House is sure to be damned by the other. And when one party perceives the other has the advantage, they play truant, and an officer or a mob hunt the absconding members in all the streets and alleys and towns. Such farces have been repeated in Philadelphia, and there alone. Had the legislature been framed with some check upon rash proceedings, the honor of the state would have been saved. The party spirit would have died with the measures proposed in the legislature. But now any measure may be carried by party in the House. It then becomes a law and sows the seeds of dissension throughout the state. Footnote: I cannot help remarking the singular jealousy of the Constitution of Pennsylvania, which requires that a bill shall be published for the consideration of the people before it is enacted into a law, except in extraordinary cases. This annihilates the legislature and reduces it to an advisory body. It almost wholly supersedes the uses of representation, the most excellent improvement in modern governments. Besides the absurdity of constituting a legislature without supreme power, such a system will keep the state perpetually embroiled. It carries the spirit of discussion into all quarters without the means of reconciling the opinions of men who are not assembled to hear each other's arguments. They debate with themselves, form their own opinions without the reasons which influence others, and without the means of information. Thus, the warmth of different opinions, which in other states dies in the legislature, is diffused through the state of Pennsylvania and becomes personal and permanent. The seeds of dissension are sown in the Constitution, and no state except Rhode Island is so distracted by factions. End footnote. 1,000 examples similar to the foregoing may be produced, both in ancient and modern history. Many plausible things may be said in favor of pure democracy, many in favor of uniting the representatives of the people in a single house, but uniform experience proves both to be inconsistent with the peace of society and the rights of freemen. The state of Georgia has already discovered such inconveniences in its constitution that a proposition has been made for altering it, and there is a prospect that a revisal will take place. People who have heard and read of the European governments founded on the different ranks of monarch, nobility, and people seem to view the Senate in America, where there is no difference of ranks and titles, as a useless branch, or as a servile imitation of foreign constitutions of governments, without the same reasons. This is a capital mistake. Our senates, it is true, are not composed of a different order of men, but the same reasons, the same necessity for distinct branches of the legislature exists in all governments. But in most of our American constitutions we have all the advantages of checks and balance, without the danger which may arise from a superior and independent order of men. It is worth our while to institute a brief comparison between our American forms of government and the two best constitutions that ever existed in Europe, the Roman and the British. In England, the king or supreme executive officer is hereditary. In America, the President of the United States is elective. That this is an advantage will hardly be disputed. In ancient Rome, the king was elective, and so were the consuls, who were the executive officers in the Republic. But they were elected by the body of the people in their public assemblies, and this circumstance paved the way for such excessive bribery and corruption as are wholly unknown in modern times. The President of the United States is also elective, but by a few men, chosen by the several legislatures under their inspection, separated at a vast distance, and holding no office under the United States. Such a mode of election almost precludes the possibility of corruption. Besides, no state, however large, has the power of choosing a president in that state, for each elector must choose at least one man who is not an inhabitant of that state to which he belongs. The crown of England is hereditary. The consuls in Rome were chosen annually. Both these extremes are guarded against in our proposed constitution. The president is not dismissed from his office. As soon as he is acquainted with business, he continues 4 years and is re-eligible if the people approve his conduct. Nor can he canvass for his office by reason of the distance of the electors, and the pride and jealousy of the states will prevent his continuing too long in office. The age requisite to qualify for this office is 35 years. Footnote: in the decline of the Republic, bribery or military force obtained this office for persons who had not attained this age. Augustus was chosen at the age of 20, or rather obtained it with his sword. End footnote. The age requisite for admittance to the Roman consulship was 43 years. For this difference good reasons may be assigned. The improvements in science, and particularly in government, render it practicable for a man to qualify himself for an important office much earlier in life than he could among the Romans, especially in the early part of their commonwealth when the office was instituted. Besides, it is very questionable whether any inconvenience would have attended an admission to the consulship at an earlier age. The powers vested in the president resemble the powers of the supreme magistrates in Rome. They are not so extensive as those of the British king, but in one instance the president with concurrence of the Senate has powers exceeding those of the Roman consuls. I mean in the appointment of judges and other subordinate executive officers. The praetors or judges in Rome were chosen annually by the people. This was a defect in the Roman government. 1/2 the evils in a state arise from a lax execution of the laws, and it is impossible that an executive officer can act with vigor and impartiality when his office depends on the popular voice. An annual popular election of executive officers is the sure source of a negligent, partial, and corrupt administration. The independence of the judges in England has produced a course of the most just, impartial, and energetic judicial decisions for many centuries that can be exhibited in any nation on earth. In this point, therefore, I conceive the plan proposed in America to be an improvement on the Roman Constitution. In all free governments, that is, in all countries where laws govern and not men, the supreme magistrate should have it in his power to execute any law, however unpopular, without hazarding his person or office. The laws are the sole guardians of right, and when the magistrate dares not act, every person is insecure. Let us now attend to the constitution and powers of the Senate. The House of Lords in England is wholly independent on the people. The Lords spiritual hold their seats by office, and the people at large have no voice in disposing of the ecclesiastical dignities. The temporal lords hold their seats by hereditary right or by grant from the king, and it is a branch of the king's prerogative to make what peers he pleases. The Senate in Rome was elective, but a senator held his seat for life. Footnote: I say the Senate was elective, but this must be understood with some exceptions, or rather qualifications. The constitution of the Roman Senate has been a subject of inquiry with the first men in modern ages. Lord Chesterfield requested the opinion of the learned Vertot upon the manner of choosing senators in Rome, and it was a subject of discussion between Lord Harvey and Dr. Middleton. The most probable account of the manner of forming the Senate and filling up vacancies which I have collected from the best writers on the subject is here abridged for the consideration of the reader. Romulus chose 100 persons from the principal families in Rome to form a council or senate, and reserved to himself the right of nominating their successors, that is, of filling vacancies. Mas come Romulus avoit lui meme choice les premiers senateurs il fait referva le droit de nommer afin gré leurs successors, mably for les Romains. Other well-informed historians intimate that Romulus retained the right of nominating the president only. After the union of the Sabines with the Romans, Romulus added another 100 members to the Senate, but by consent of the people. Tarquin the Ancient added another 100, but historians are silent as to the manner. On the destruction of Alba by Hostilius, some of the principal Alban families were added to the Senate by consent of the Senate and people. After the demolition of the monarchy, Appius Claudius was admitted into the Senate by order of the people. Cicero testifies that from the extinction of the monarchy, all the members of the Senate were admitted by command of the people. It is observable that the first creation of the senators was the act of monarch, and the first patrician families claimed the sole right of admission into the Senate. Les familles qui defendiose des deux senateurs que Romulus avoit créés, se crusant sous les droits d'entrer dans le Sénat. Mabley. This right, however, was not granted in its utmost extent, for many of the senators in the Roman Commonwealth were taken from plebeian families. For 60 years before the institution of the censorship, which was AUC 311, we are not informed how vacancies in the Senate were supplied. The most probable method was this: to enroll in the list of senators the different magistrates, viz. The consuls, praetors, the 2 quaestors of patrician families, the 5 tribunes, afterwards 10, and the 2 aediles of plebeian families. The office of quaestor gave an immediate admission into the Senate. The tribunes were admitted 2 years after their creation. This enrollment seems to have been a matter of course, and likewise their confirmation by the people in their comita or assemblies. On extraordinary occasions, when the vacancies of the Senate were numerous, the consuls used to nominate some of the most respectable of the equestrian order, to be chosen by the people. On the institution of the censorship, the censors were invested with full powers to inspect the manners of the citizens, enroll them in their proper ranks according to their property, make out lists of the senators, and leave out the names of such as had rendered themselves unworthy of their dignity by any scandalous vices. This power they several times exercised, but the disgraced senators had an appeal to the people. After the Senate had lost half its members in the war with Hannibal, the dictator, M. Fabius Buto, filled up the number with the magistrates, with those who had been honored with a civic crown, or others who were respectable for age and character. 170 new members were added at once with the approbation of the people. The vacancies occasioned by Sylla's prescriptions amounted to 300, which were supplied by persons nominated by Sylla and chosen by the people. Before the time of the Gracchi, the number of senators did not exceed 300, but in Sylla's time, so far as we can collect from indirect testimonies, it amounted to about 500. The age necessary to qualify for a seat in the Senate is not exactly ascertained, but several circumstances prove it to have been about 30 years. See Vertot, Mabley, and Middleton on this subject. In the last ages of Roman splendor, the property requisite to qualify a person for a senator was settled by Augustus at 800 sestertia, more than 6,000 pounds sterling. End footnote. The proposed Senate in America is constituted on principles more favorable to liberty. The members are elective and by the separate legislatures. They hold their seats for 6 years. They are thus rendered sufficiently dependent on their constituents, and yet are not dismissed from their office as soon as they become acquainted with the forms of proceeding. It may be objected by the larger states that the representation in the Senate is not equal, the smallest states having the privilege of sending the same number of senators as the largest. To obviate this objection, I would suggest but 2 or 3 ideas. 1. If each state had a representation and a right in deciding questions proportional to its property, 3 states would almost command the whole. Such a constitution would gradually annihilate the small states, and finally melt down the whole United States into one undivided sovereignty. The free states of Spain and the Heptarchy in England afford striking examples of this. Should it be said that such an event is desirable, I answer, the states are all entitled to their respective sovereignties, and while they claim independence in internal jurisdiction, the federal constitution ought to guarantee their sovereignty. 2. Another consideration has weight. There is in all nations a tendency towards an accumulation of power in some point. It is the business of the legislator to establish some barriers to check that tendency. In small societies, a man worth 100,000 pounds sterling has but 1 vote, when his neighbors who are worth but 50 pounds have each 1 vote likewise. To make property the sole basis of authority would expose many of the best citizens to violence and oppression. To make the number of inhabitants in a state the rule of apportioning power is more immutable, and where the United States one indivisible interest would be a perfect rule for representation. But the detached situation of the states has created some separate interests, some local institutions which they will not resign nor throw into the hands of other states. For these peculiar interests the states have an equal attachment. For the preservation and enjoyment of these an equal sovereignty is necessary, and the sovereignty of each state would not be secure had each state in both branches of the legislature an authority in passing laws proportioned to its inhabitants. 3. But the Senate should be considered as representing the Confederacy in a body. It is a false principle in the vulgar ideas of representation that a man delegated by a particular district in a state is the representative of that district only, whereas in truth a member of the legislature from any town or county is the representative of the whole state. In passing laws, he is to view the whole collective interest of the state, and act from that view, not from a partial regard to the interest of the town or county where he is chosen. End of section 2.
Section 3 of An Examination into the Leading Principles of the Federal Constitution. This is a LibriVox recording. All LibriVox recordings are in the public domain. For more information or to volunteer, please visit LibriVox.org. Read by Janet Wedge. An Examination into the Leading Principles of the Federal Constitution by Noah Webster. The same principle extends to the Congress of the United States. A delegate is bound to represent the true local interest of his constituents, to state it in its true light to the whole body. But when each provincial interest is thus stated, every member should act for the aggregate interest of the whole Confederacy. The design of representation is to bring this collective interest into view. A delegate is not the legislator of a single state. He is as much the legislator of the whole Confederacy as of the particular state where he is chosen. And if he gives his vote for a law which he believes to be beneficial to his own state only, and pernicious to the rest, he betrays his trust and violates his oath. It is indeed difficult for a man to divest himself of local attachments and act from an impartial regard to the general good. But he who cannot, for the most part, do this is not a good legislator. These considerations suggest the propriety of continuing the senators in office for a longer period than the representatives. They gradually lose their partiality, generalize their views, and consider themselves as acting for the whole Confederacy. Hence, in the Senate, we may expect union and firmness. Here we may find the general good the object of legislation, and a check upon the more partial and interested acts of the other branch. These considerations obviate the complaint that the representation in the Senate is not equal, for the senators represent the whole Confederacy, and all that is wanted of the members is information of the true situation and interest of each state. As they act under the direction of the several legislatures, 2 men may as fully and completely represent a state as 20. And when the true interest of each state is known, if the senators perform the part of good legislators and act impartially for the whole collective body of the United States, it is totally immaterial where they are chosen. It is a capital defect of most of the state constitutions that the senators, like the representatives, are chosen in particular districts. They are thus inspired with local views, and however wrong it may be to entertain them, yet such is the constitution of human nature that men are almost involuntarily attached to the interest of the district which has reposed confidence in their abilities and integrity. Some partiality, therefore, for constituents is always expectable. To destroy it as much as possible, a political constitution should remove the grounds of local attachment. Connecticut and Maryland have wisely destroyed this attachment in their senates by ordaining that the members shall be chosen in the state at large. The senators hold their seats by the suffrages of the state, not of a district. Hence, they have no particular number of men to fear or to oblige. They represent the state. Hence, that union and firmness which the senates of those states have manifested on the most trying occasions, and by which they have prevented the most rash and iniquitous measures. It may be objected that when the election of senators is vested in the people, they must choose men in their own neighborhood, or else those with whom they are unacquainted. With respect to representatives, this objection does not lie, for they are chosen in small districts, and as to senators, there is in every state a small number of men whose reputation for abilities, integrity, and good conduct will lead the people to a very just choice. Old, experienced statesmen should compose the Senate, and people are generally, in this free country, acquainted with their characters. Were it possible, as it is in small states, it would be an improvement in the doctrine of representation to give every free man the right of voting for every member of the legislature, and the privilege of choosing the men in any part of the state. This would totally exclude bribery and undue influence, for no man can bribe a state, and it would almost annihilate partial views in legislation. But in large states, it may be impracticable. The House of Representatives is the more immediate voice of the separate states. Here the states are represented in proportion to their number of inhabitants. Here the separate interests will operate with their full force, and the violence of parties and the jealousies produced by interfering interests can be restrained and quieted only by a body of men less local and dependent. It may be objected that no separate interests should exist in a state, and a division of the legislature has a tendency to create them. But this objection is founded on mere jealousy, or a very imperfect comparison of the Roman and British governments with the proposed federal constitution. The House of Peers in England is a body originally and totally independent on the people. The Senate in Rome was mostly composed of patrician or noble families, and after the first election of a senator, he was no longer dependent on the people. He held his seat for life. But the Senate of the United States can have no separate interests from the body of the people, for they live among them. They are chosen by them. They must be dismissed from their place once in 6 years and may at any time be impeached for malpractices. Their property is situated among the people and with their persons subject to the same laws. No title can be granted but the temporary titles of office bestowed by the voluntary election of the people, and no preeminence can be acquired but by the same means. The separation of the legislature divides the power, checks, restrains, amends the proceedings. At the same time, it creates no division of interest that can tempt either branch to encroach upon the other or upon the people. In turbulent times, such restraint is our greatest safety. In calm times, and in measures obviously calculated for the general good, both branches must always be unanimous. A man must be 30 years of age before he can be admitted into the Senate, which was likewise a requisite in the Roman government. What property was requisite for a senator in the early ages of Rome, I cannot inform myself, but Augustus fixed it at 800 sestertia, between 6 and 7,000 pounds sterling. In the federal constitution, money is not made a requisite. The places of senators are wisely left open to all persons of suitable age and merit, and who have been citizens of the United States for 9 years, a term in which foreigners may acquire the feelings and acquaint themselves with the interests of the native Americans. The House of Representatives is formed on very equitable principles and is calculated to guard the privileges of the people. The English House of Commons is chosen by a small part of the people in England and continues for 7 years. The Romans never discovered the secret of representation. The whole body of citizens assembled for the purposes of legislation, a circumstance that exposed their government to frequent convulsions and to capricious measures. The federal House of Representatives is chosen by the people, qualified to vote for state representatives, and continues 2 years. Note, it is said by Rome that no property should be required as a qualification for an elector. I shall not enter into a discussion of the subject, but remark that in most free governments, some property has been thought requisite to prevent corruption and secure government from the influence of an unprincipled multitude. In ancient Rome, none but the free citizens had the right of suffrage in the comitia, or legislative assemblies. But in Sylla's time, the Italian cities demanded the rights of the Roman citizens, alleging that they furnished 2/3 of the armies in all their wars, and yet were despised as foreigners. Veli Paterc Lib. A. Cap. 25. This produced the Marsic, or social war, which lasted 2 years and carried off 300,000 men, 1 B.M. It was conducted and concluded by Pompey, father of Pompey the Great, with his lieutenants Sylla and Marius. But most of the cities eventually obtained the freedom of Rome and were, of course, entitled to the rights of suffrage in the comitia. Polatim de inde recipiendo in civitatem, qui arma aut non severant, aut deposuerant, maturius vires resectae sunt. Vel Paterc 2:16. But Rome had cause to deplore this event, for however reasonable it might appear to admit the allies to a participation of the rights of citizens, yet the concession destroyed all freedom of election. It enabled an ambitious demagogue to engage and bring into the assemblies whole towns of people, slaves and foreigners, and everything was decided by faction and violence. This Montesquieu numbers among the causes of the decline of the Roman greatness. De la grandeur des Romains, e.g. Representation would have, in some measure, prevented these consequences, but the admission of every man to a suffrage will ever open the door to corruption. In such a state as Connecticut, where there is no conflux of foreigners, no introduction of seamen, servants, and so forth, and scarcely 100 persons in the state who are not natives, and very few whose education and connections do not attach them to the government. At the same time, few men have property to furnish the means of corruption. Very little danger could spring from admitting every man of age and discretion to the privilege of voting for rulers. But in the large towns of America there is more danger. A matter of a vessel may put votes into the hands of his crew for the purpose of carrying an election for a party. Such things have actually taken place in America. Besides, the Middle States are receiving emigrations of poor people who are not at once judges of the characters of men and who cannot be fairly trusted with the choices of legislators. Some may object to their continuance in power 2 years, but I cannot see any danger arising from this quarter. On the contrary, it creates less trouble for the representatives who by such choice are taken from their professions and obliged to attend Congress, some of them at the distance of at least 700 miles. While men are chosen by the people and responsible to them, there is but little danger from ambition or corruption. If it should be said that Congress may in time become triennial and even septennial, like the English parliaments, I answer, this is not in their power. The English Parliament had power to prolong the period of their existence, but Congress will be restrained by the different legislatures without whose constitutional concurrence no alteration can be made in the proposed system. The fourth section, Article 1 of the new Constitution, declares that the times, places, and manner of holding elections for senators and representatives shall be prescribed in each state by the legislature thereof, but the Congress may at any time by law make or alter such regulations, except as to the places of choosing senators. Here let us pause. What did the convention mean by giving Congress power to make regulations prescribed by the legislatures? Is this expression accurate or intelligible? But the word alter is very intelligible, and the clause puts the election of representatives wholly and the senators almost wholly in the power of Congress. The views of the convention I believe to be perfectly upright. They might mean to place the election of representatives and senators beyond the reach of faction. They doubtless had good reasons in their minds for the clause, but I see no occasion for any power in Congress to interfere with the choice of their own body. They will have power to suppress insurrections, as they ought to have, but the clause in italics gives needless and dangerous powers. I hope the states will reject it with decency and adopt the whole system without altering another syllable. The method of passing laws in Congress is much preferable to that of ancient Rome or modern Britain. Not to mention other defects in Rome, it lay in the power of a single tribune to obstruct the passing of a law. As the tribunes were popular magistrates, the right was often exercised in favor of liberty, but it was also abused, and the best regulations were prevented to gratify the spleen, the ambition, or the resentment of an individual. The King of Great Britain has the same power, but seldom exercises it. It is, however, a dangerous power. It is absurd and hazardous to lodge in one man the right of controlling the will of a state. Every bill that passes a majority of both houses of Congress must be sent to the President for his approbation, but it must be returned in 10 days, whether approved by him or not, and the concurrence of 2/3 of both houses passes the bill into a law, notwithstanding any objections of the President. The Constitution, therefore, gives the Supreme Executive a check, but no negative, upon the sense of Congress. End of section 3. Section 4. An examination into the leading principles of the Federal Constitution. This is a LibriVox recording. All LibriVox recordings are in the public domain. For more information or to volunteer, please visit LibriVox.org, read by Janet Wedge, and Examination into the Leading Principles of the Federal Constitution by Noah Webster, Section 4. The powers lodged in Congress are extensive, but it is presumed that they are not too extensive. The first object of the Constitution is to unite the states into one compact society for the purpose of government. If such union must exist, or if the states be exposed to foreign invasions, internal discord, reciprocal encroachments upon each other's property, to weakness and infamy, which no person will dispute, what powers must be collected and lodged in the supreme head or the legislature of these states? The answer is easy. This legislature must have exclusive jurisdiction in all matters in which the states have a mutual interest. There are some regulations in which all the states are equally concerned. There are others which, in their operation, are limited to one state. The first belong to Congress, the last to the respective legislatures. No one state has a right to supreme control in any affair in which the other states have an interest, nor should Congress interfere in any affair which respects one state only. This is the general line of division which the Convention have endeavored to draw between the powers of Congress and the rights of the individual states. The only question, therefore, is whether the new Constitution delegates to Congress any powers which do not respect the general interest and welfare of the United States. If these powers entrench upon the present sovereignty of the state, without having for an object the collective interest of the whole, the powers are too extensive. But if they do not extend to all concerns in which the states have a mutual interest, they are too limited. If in any instance the powers necessary for protecting the general interest interfere with the constitutional rights of an individual state, such state has assumed powers that are inconsistent with the safety of the United States, and which ought instantly to be resigned. Considering the states as individuals on equal terms, entering into a social compact, no state has a right to any power which may prejudice its neighbors. If, therefore, the federal Constitution has collected into the federal legislature no more power than is necessary for the common defense and interest, it should be recognized by the states, however particular clauses may supersede the exercise of certain powers by the individual states. This question is of vast magnitude. The states have very high ideas of their separate sovereignties, although it is certain that while each exists in its full latitude, we can have no federal sovereignty. However flattered each state may be by its independent sovereignty, we can have no union, no respectability, no national character, and what is more, no national justice, till the states resign to one supreme head the exclusive power of legislating, judging, and executing in all matters of a general nature. Everything of a private or provincial nature must still rest on the ground of the respective state constitutions. After examining the limits of the proposed congressional powers, I confess I do not think them too extensive. I firmly believe that the life, liberty, and property of every man, and the peace and independence of each state, will be more fully secured under such a constitution of federal government than they will under a constitution with more limited powers, and infinitely more safe than under our boasted distinct sovereignties. It appears to me that Congress will have no more power than will be necessary for our union and general welfare. And such power they must have, or we are in a wretched state. On the adoption of this Constitution, I should value real estate 20% higher than I do at this moment. I will not examine into the extent of the powers proposed to be lodged in the Supreme Federal Head. The subject would be extensive and require more time than I can bestow upon it. But I will just take up some objections that have been made to particular points of the new Constitution. Most of the objections I have yet heard to the Constitution consist in mere insinuations unsupported by reasoning or fact. They are thrown out to instill groundless jealousies into the minds of the people, and probably with a view to prevent all government. For there are in every society some turbulent geniuses whose importance depends solely on faction. To shew the insidious and detestable nature of these insinuations, it is necessary to mention and remark on a few particulars. 1. The first objection against the Constitution is that the legislature will be more expensive than our present Confederation. This is so far from being true that the money we actually lose by our present weakness, disunion, and want of government would support the civil government of every state in the Confederacy. Our public poverty does not proceed from the expensiveness of Congress, nor of the civil list, but from want of power to command our own advantages. We pay more money to foreign nations in the course of business, and merely for want of government, than would, under an efficient government, pay the annual interest of our domestic debt. Every man in business knows this to be truth, and the objection can be designed only to delude the ignorant. 2. Another objection to the Constitution is the division of the legislature into two branches. Luckily, this objection has no advocates but in Pennsylvania, and even here their number is dwindling. The factions that reign in this state, the internal discord and passions that disturb the government and the peace of the inhabitants, have detected the errors of the Constitution and will sometime or other produce a reformation. The division of the legislature has been the subject of discussion in the beginning of this essay and will be deemed by 19/20ths of the Americans one of the principal excellencies of the Constitution. 3. A third insinuation is that the proposed federal government will annihilate the several legislatures. This is extremely disingenuous. Every person capable of reading must discover that the convention have labored to draw the line between the federal and provincial powers, to define the powers of Congress, and limit them to those general concerns which must come under federal jurisdiction and which cannot be managed in the separate legislatures, that in all internal regulations, whether of civil or criminal nature, the states retain their sovereignty and have it guaranteed to them by this very Constitution. Such a groundless insinuation, or rather mere surmise, must proceed from dark designs or extreme ignorance, and deserves the severest reprobation. It is alleged that the liberty of the press is not guaranteed by the new Constitution, but this objection is wholly unfounded. The liberty of the press does not come within the jurisdiction of federal government. It is firmly established in all the states, either by law or positive declarations in bills of right, and not being mentioned in the federal Constitution is not and cannot be abridged by Congress. It stands on the basis of the respective state constitutions. Should any state resign to Congress the exclusive jurisdiction of a certain district, which should include any town where presses are already established, it is in the power of the state to reserve the liberty of the press or any other fundamental privilege, and make it an immutable condition of the grant that such rights shall never be violated. All objections, therefore, on this score are baseless visions. It is insinuated that the Constitution gives Congress the power of levying internal taxes at pleasure. This insinuation seems founded on the 8th section of the 6th article, which declares that Congress shall have power to lay and collect taxes, duties, imposts, and excises, to pay the debts and provide for the common defense and general welfare of the United States. That Congress should have power to collect duties, imposts, and excises in order to render them uniform throughout the United States will hardly be controverted. The whole objection is to the right of levying internal taxes. But it will be conceded that the supreme head of the states must have power competent to the purposes of our Union, or it will be, as it now is, a useless body, a mere expense without any advantage. To pay our public debt, to support foreign ministers, and our own civil government, money must be raised. And if the duties and imposts are not adequate to these purposes, where shall the money be obtained? It will be answered, let Congress apportion the sums to be raised, and leave the legislatures to collect the money. Well, this is all that is intended by the clause under Confederation, with the addition of a federal power that shall be sufficient to oblige a delinquent state to comply with the requisition. Such power must exist somewhere, or the debts of the United States can never be paid. For want of such power, our credit is lost, and our internal faith is a byword. For want of such power, one state now complies fully with the requisition, another partially, and a third absolutely refuses or neglects to grant a shilling. Thus the honest and punctual are doubly loaded, and the knave triumphs in his negligence. In short, no honest man will dread a power that shall enforce an equitable system of taxation. The dishonest are ever apprehensive of a power that shall oblige them to do what honest men are ready to do voluntarily. End of section 4.
Section 5 of an examination into the leading principles of the Federal Constitution. This is a LibriVox recording. All LibriVox recordings are in the public domain. For more information or to volunteer, please visit LibriVox.org. Read by Robert H. Cherny. An examination into the leading principles of the Federal Constitution by Noah Webster. Permit me to ask those who object to this power of taxation, how shall money be raised to discharge our honest debts, debts which are universally acknowledged to be just? Have we not already experienced the inefficiency of a system without power? Has it not been proved to demonstration that a voluntary compliance with the demands of the Union can never be expected? To what expedient shall we have recourse? What is the resort of all governments in case of delinquency? Do not the states vest in the legislature, even in the governor and council, a power to enforce laws, even with the militias of the states? And how rarely does there exist a necessity of exerting such a power? Why should such a power be more dangerous in Congress than in a legislature? Why should more confidence be reposed in a member of one legislature than of another? Why should we choose the best men in the state to represent us in Congress, and the moment they are elected, arm ourselves against them as tyrants and robbers? Do we not in this conduct act the part of a man who, as soon as he has married a woman of unsuspected chastity, locks her up in a dungeon? Is there any spell or charm that instantly changes a delegate to Congress from an honest man into a knave, a tyrant? I confess freely that I am willing to trust Congress with any powers that I should dare lodge in a state legislature. I believe life, liberty, and property would be as safe in the hands of a federal legislature, organized in the manner proposed by the convention, as in the hands of any legislature that has ever been or ever will be chosen in any particular state. But the idea that Congress can levy taxes at pleasure is false, and the suggestion wholly unsupported. The preamble to the Constitution is declaratory of the purpose of our Union and the assumption of any powers not necessary to establish justice, ensure domestic tranquility, provide for the common defense, promote the general welfare, and to secure the blessings of liberty to ourselves and our posterity will be unconstitutional and endanger the existence of Congress. Besides, in the very clause which gives the power of levying duties and taxes, the purposes to which the money shall be appropriated are specified, vis-a-vis to pay the debts and provide for the common defense and general welfare of the United States. Footnote. For these purposes, money must be collected, and the power of collection must be lodged, sooner or later, in a federal head, or the common defense and the general welfare must be neglected. Footnote. The clause may at first appear ambiguous. It may be uncertain whether we should read and understand it thus. The Congress shall have the power to lay and collect taxes, duties, imposts, and excises in order to pay the debts, etc. Or whether the meaning is, Congress shall have power to lay and collect taxes, duties, imposts, and excises, and shall have power to pay the debts, etc. On considering the construction of the clause and comparing it with the preamble, the last sense seems to be improbable and absurd. But it is not very material, for no powers are vested in Congress but what are included under the general expressions of providing for the common defense and general welfare of the United States. Any powers not promotive of these purposes will be unconstitutional. Consequently, any appropriations of money to any other purpose will expose the Congress to the resentment of the states, and the members to impeachment and loss of their seats. End footnote. The states, in their separate capacity, cannot provide for the common defense. Nay, in case of a civil war, a state cannot secure its own existence. The only question, therefore, is whether it is necessary to unite and provide for our common defense and general welfare. For this question, once being decided in the affirmative, leaves no room to controvert the propriety of constituting a power over the whole United States adequate to these general purposes. The states, by granting such power, do not throw it out of their own hands. They only throw, each its proportion, into a common stock. They merely combine the powers of the several states into one point, where they must be collected before they can be exerted. But the powers are still in their own hands and cannot be alienated till they create a body independent of themselves with a force of command superior to the whole yeomanry of the country. 6. It is said that there is no provision made in the new Constitution against a standing army in time of peace. Why do not people object that no provision is made against the introduction of a body of Turkish janissaries, or against making the Alcoran the rule of faith and practice instead of the Bible? The answer to such objections is simply this: no such provision is necessary. The people in this country cannot forget their apprehensions from a British standing army quartered in America, and they turn their fears and jealousies against themselves. Why do not the people of most of the states apprehend danger from standing armies from their own legislatures? Pennsylvania and North Carolina, I believe, are the only states that have provided against this danger at all events. Other states have declared that no standing armies shall be kept up without the consent of the legislature. But this leaves the power entirely in the hands of the legislature. Many of the states, however, have made no provision against this evil. What hazards these states suffer! Why does not a man pass a law in his family that no armed soldier shall be quartered in his house by his consent? The reason is very plain. No man will suffer his liberty to be abridged or endangered. His disposition and his power are uniformly opposed to any infringement of his rights. In the same manner, the principles and habits as well as the power of the Americans are directly opposed to standing armies, and there is as little necessity to guard against them by positive constitutions as there is to prohibit the establishment of the Mohammedan religion. But the Constitution provides for our safety, and while it gives Congress power to raise armies, it declares that no appropriation of money to their support shall be for a longer term than 2 years. Congress, likewise, are to have the power to provide for organizing, arming, and disciplining the militia, but have no other command of them except when in actual service. Nor are they at liberty to call out the militia at pleasure, but only to execute the laws of the Union, suppress insurrections, and repel invasions. For these purposes, government must always be armed with a military force if the occasion should require it. Otherwise, laws are nugatory and life and property insecure. 7. Some persons have ventured to publish an intimation that by the proposed Constitution, the trial by jury is absolved in all civil cases. Others very modestly insinuate that it is in some cases only. The fact is that trial by jury is not affected in any case by the Constitution, except in cases of impeachment which are to be tried by the Senate. None but persons in office in or under Congress can be impeached, and even after a judgment upon an impeachment, the offender is liable to a prosecution before a common jury in a regular course of law. The insinuation, therefore, that trials by jury are to be abolished is groundless and beyond conception wicked. It must be wicked because the circulation of such a barefaced falsehood respecting a privilege dear to freemen can proceed only from a depraved heart and the worst intentions. 8. It is also intimated as a probable event that the federal courts will absorb the judiciaries of several states. This is a mere suspicion without the least foundation. The jurisdiction of the federal courts is very accurately defined and easily understood. It extends to the cases mentioned in the Constitution and to the execution of the laws of Congress respecting commerce, revenue, and other general concerns. With respect to all other civil and criminal actions, the powers and jurisdictions of the several judiciaries of each state remain unimpaired. Nor is there anything novel in allowing appeals to the Supreme Court. Actions are mostly to be tried in the state where the crimes are committed. But appeals are allowed under our present Confederation, and no person complains. Nay, were they no appeal, every man would have reason to complain, especially when a final judgment in an inferior court should affect property to a large amount. But why is an objection raised against an appellate jurisdiction in the Supreme Court representing fact as well as law? Is it less safe to have the opinions of 2 juries than of 1? I suspect many people will think this no defect in the Constitution, but perhaps it will destroy a material requisite of a good jury, vis-a-vis their vicinity to the cause of action. I have no doubt that when cases were tried in periods prior to the Christian era, before 12 men seated upon 12 stones, arranged in a circular form under a large oak, there was a great propensity in submitting causes to men in the vicinity. The difficulty of collecting evidence in those rude times rendered it necessary that juries should judge mostly from their own knowledge of facts or from information obtained out of court. But in these polished times, when juries depend almost wholly on the testimony of witnesses, and when a complication of interests introduced by commerce and other causes renders it almost impossible to collect men in the vicinity of the parties who are wholly disinterested, it is no disadvantage to have the cause tried by a jury of strangers. Indeed, the latter is generally the most eligible. But the truth is, the creation of all inferior courts is in the power of Congress, and the Constitution provides that the Congress shall make such exceptions from the right of appeals as they shall judge proper. When these courts are erected, their jurisdictions will be ascertained, and in small actions, Congress will doubtless direct that a sentence in a subordinate court shall to a certain amount be definitive and final. All objections, therefore, to the judicial powers of the federal courts appear to me as trifling of any of the preceding. 9. But, say the enemies of slavery, Negroes may be imported for 21 years. This exception is addressed to the Quakers, and a very pitiful exception it is. The truth is, Congress cannot prohibit the importation of slaves during that period, but the laws against the importation into particular states stand unrepealed. An immediate abolition of slavery would bring ruin upon the whites and misery upon the blacks in the southern states. The Constitution has therefore wisely left each state to pursue its own measures with respect to this article of legislation during the period of 21 years. This is the end of Section 5. Section 6 of an examination into the leading principles of the Federal Constitution. This is a LibriVox recording. All LibriVox recordings are in the public domain. For more information or to volunteer, please visit LibriVox.org. Read by Robert H. Cherny. An examination into the leading principles of the Federal Constitution by Noah Webster. Such are the principal objections that have yet been made by the enemies of the new Constitution. They are mostly frivolous or founded on false constructions and a misrepresentation of the true state of facts. They are evidently designed to raise groundless jealousies in the minds of well-meaning people who have little leisure and opportunity to examine into the principles of government. But a little time and reflection will enable most people to detect such mischievous intentions, and the spirit and firmness which have distinguished the conduct of the Americans during the conflict for independence will eventually triumph over the enemies of our Union and bury them in disgrace or oblivion. But I cannot quit this subject without attempting to correct some erroneous opinions respecting freedom and tyranny, and the principles by which they are supported. Many people seem to entertain an idea that liberty consists in a power to act without any control. This is more liberty than even the savages enjoy, but in civil society, political liberty consists in acting conformably to the sense of a majority of the society. In a free government, every man binds himself to obey the public voice, or the opinions of a majority, and the whole society engages to protect each individual. In such a government, a man is free and safe. But reverse the case. Suppose every man to act without control or fear of punishment. Every man would be free, but no man would be sure of his freedom one moment. Each would have the power of taking his neighbor's life, liberty, or property, and no man would command more than his own strength to repel the invasion. The case is the same with states. If the states should not unite into one compact society, every state may trespass upon its neighbor, and the injured state has no means of redress but its own military force. The present situation of our American states is very little better than a state of nature. Our boasted state sovereignties are so far from securing our liberty and property that they every moment expose us to the loss of both. That state which commands the heaviest purse and longest sword may at any moment lay its weaker neighbor under tribute, and there is no superior power now existing that can regularly oppose the invasion or redress the injury. From such liberty, O Lord, deliver us. But what is tyranny? Or how can a free people be deprived of their liberties? Tyranny is the exercise of some power over a man which is not warranted by law or necessary for the public safety. A people can never be deprived of their liberties while they retain in their own hands a power superior to any other power in the state. This position leads me directly to inquire, in what consists the power of a nation or of an order of men? In some nations, legislators have derived much of their power from the influence of religion, or from that implicit belief which an ignorant or superstitious people entertain of the gods, and their interposition in every transaction of life. The Roman Senate sometimes availed themselves of this engine to carry their decrees and maintain their authority. This was particularly the case under the aristocracy which succeeded the abolition of the monarchy. The augurs and priests were taken wholly from patrician families. Footnote: Quod nemo plebeius auspicia hyberet idioc decemaverius canubum diarmis ne inserte prole auspicia terrabertur. Titus Livius, Library 4, Caption 6. End footnote. They constituted a distinct order of men and had power to negative any law of the people by declaring that it was passed during the taking of the auspices. Footnote: Augurus certe sacerdostique augurum tantus honus accitit ut nihili belle Dominique postii nisi auspiciato geritor, concilia populi excitia vocati sumo rerum ubi avis non amissint derimuntur. Titus Livius, Library 1, Caption 37. End footnote. The influence derived from the authority of opinion was less perceptible, but as tyrannical as a military force. The same influence constitutes at this day a principal support of several governments on the eastern continent and perhaps in South America. But in North America, by a singular concurrence of circumstances, the possibility of establishing this influence as a pillar of government is wholly precluded. Another source of power in government is a military force. But this, to be efficient, must be superior to any force that exists among the people or which they can command, for otherwise this force would be annihilated on the first exercise of acts of oppression. Before a standing army can rule, the people must be disarmed, as they are in almost every kingdom in Europe. The supreme power in America cannot enforce unjust laws by the sword, because the whole body of the people are armed and constitute a force superior to any band of regular troops that can be on any pretense raised in the United States. A military force at the command of Congress can execute no laws but such as the people perceive to be just and constitutional, for they will possess the power, and jealousy will instantly inspire the inclination to resist the execution of a law which appears to them unjust and oppressive. In spite of all the nominal powers vested in Congress by the Constitution, were the system once adopted in its fullest latitude, still the actual exercise of them would be frequently interrupted by popular jealousy. I am bold to say that 10 just and constitutional measures would be resisted where one unjust or oppressive law would be enforced. The powers vested in Congress are little more than nominal. Nay, real power cannot be vested in them, nor in anybody but in the people. The source of power is in the people of this country, and cannot for ages, and probably never will, be removed. In what then does real power consist? The answer is short and plain. In property. Could we want any proofs of this which are not exhibited in this country, the uniform testimony of history will furnish us with multitudes. But I will go no further for proof than the two governments already mentioned, the Roman and the British. Rome exhibited a demonstrative proof of the inseparable connection between property and dominion. The first form of its government was an elective monarchy. Its second, an aristocracy, but these forms could not be permanent because they were not supported by property. The kings at first and afterwards the patricians had nominally most of the power, but the people, possessing most of the lands, never ceased to assert their privileges till they established a commonwealth, and the kings and senate could not have held the reins of government in their hands so long as they did, had they not artfully contrived to manage the established religion and play off the superstitious credulity of the people against their own power. Thus, this weak constitution of government, says the ingenious Mr. Moyle, speaking of the aristocracy of Rome, not founded on the true center of dominion, land, nor on any standing foundation of authority, nor riveted in the esteem and affections of the people, and being attacked by strong passion, general interest, and the joint forces of the people, mouldered away, of course, and pined of a lingering consumption, till it was totally swallowed up by the prevailing faction, and the nobility were molded into the mass of the people. Footnote: Essay on the Roman Government. End footnote. The people, notwithstanding the nominal authority of the patricians, proceeded regularly in enlarging their own powers. They first extorted from the Senate the right of electing tribunes, with a negative upon the proceedings of the Senate. Footnote: Titus Livius 2:33. End footnote. They had obtained the right of proposing and debating laws which before had been vested in the Senate, and finally advanced to the power of enacting laws without the authority of the Senate. Footnote: Titus Livius 3:34. End footnote. They had gained the rights of election in their comitia, of which they had been deprived by Servius Tullius. Footnote: Titus Livius 3:33. End footnote. They procured a permanent body of laws, collected from the Grecian institutions. They destroyed the influence of augurs or diviners by establishing the tributes comitia, in which they were not allowed to consult the gods. They increased their power by large accessions of conquered land. They procured a repeal of the law which prohibited marriages between the patricians and plebeians. Footnote: Titus Livius 4:6. End footnote. The Licinian law limited all politicians to 500 acres of land, which, had it been fully executed, would have secured the Commonwealth. The Romans proceeded thus step by step to triumph over the aristocracy, and to crown their privileges, they procured the right of being elected to the highest offices of the state, by acquiring the property of the plebeians, the nobility, several times held most of the power of the state, but the people, by reducing the interest of money, abolishing debts, or by forcing other advantages from the patricians, generally held the power of governing in their own hands. In America, we begin our empire with more popular privileges than the Romans ever enjoyed. We have not to struggle against a monarch or an aristocracy. Power is lodged in the mass of the people. On reviewing the English history, we observe a progress similar to that in Rome, an incessant struggle for liberty from the date of the Magna Carta in John's reign to the Revolution. The struggle has been successful by abridging the enormous power of the nobility, but we observe that the power of the people has increased in exact proportion to their acquisitions of property. Wherever the right of primogeniture is established, property must accumulate and remain in families. Thus, the landed property in England will never be sufficiently distributed to give the powers of government wholly into the hands of the people. But to assist the struggle for liberty, commerce has interposed, and in conjunction with manufactures, thrown a vast weight of property into the democratical scale. Wherever we cast our eyes, we see this truth, that property is the basis of power. And this, being established as a cardinal point, directs us to the means of preserving our freedom. Make laws, irrevocable laws in every state, destroying and barring entailments. Leave real estates to revolve from hand to hand as time and accident may direct, and no family influence can be acquired and established for a series of generations. No man can obtain dominion over a large territory. The laborious and saving, who are generally the best citizens, will possess each his share of property and power, and thus the balance of wealth and power will continue where it is, in the body of the people. A general and tolerably equal distribution of landed property is the whole basis of national freedom. The system of the great Montesquieu will ever be erroneous, till the words property or lands in fee simple are substituted for virtue throughout his spirit of laws. Virtue, patriotism, or love of country never was and never will be, till men's natures are changed, a fixed, permanent principle and support of government. But in any agricultural country, a general possession of land in fee simple may be rendered perpetual, and the inequalities introduced by commerce are too fluctuating to endanger government. An equality of property with a necessity of alienation, constantly operating to destroy combinations of powerful families, is the very soul of a republic. While this continues, the people will inevitably possess both power and freedom. When this is lost, power departs, liberty expires, and a commonwealth will eventually assume some other form. This is the end of Section 6. Section 7 of an examination into the leading principles of the Federal Constitution. This is a LibriVox recording. All LibriVox recordings are in the public domain. For more information or to volunteer, please visit LibriVox.org. Read by Robert H. Cherny. An examination into the leading principles of the Federal Constitution by Noah Webster. The liberty of the press, trial by jury, the habeas corpus writ, even Magna Carta itself, although justly deemed the palladia of freedom, are all inferior considerations when compared with a general distribution of real property among every class of people. Footnote: Montesquieu proposed virtue to be the principle of a republic. He derived his notions of this form of government from the astonishing firmness, courage, and patriotism which distinguished the republics of Greece and Rome. But this virtue consisted in pride, contempt of strangers, and a martial enthusiasm which sometimes displayed itself in defense of their country. These principles were never permanent. They decay with refinement, intercourse with other nations, and increase of wealth. No wonder, then, that these republics declined, for they were not founded on fixed principles, and hence authors imagine that republics cannot be durable. None of the celebrated writers seem to have laid sufficient stress on a general possession of real property in fee simple. Even the author of the political sketches in the museum for the month of September seems to have passed it over in silence. Although he combats Montesquieu's system to prove it false, enumerates some of the principles which distinguish our governments from others, and which he supposes constitute the support of republics. The English writers on law and government consider Magna Carta, trial by juries, the Habeas Corpus Act, and the liberty of the press as the bulwarks of freedom. All of this is well, but in no government of consequence in Europe is freedom established to its true and immovable foundation. The property is too much accumulated, and the accumulations too well guarded, to admit the true principle of republics. But few centuries have elapsed since the body of the people were vassals. To such men, the smallest extension of popular privileges was deemed an invaluable blessing. Hence the encomiums upon trial by juries and the articles just mentioned. But these people have never been able to mount to the full source of liberty, estates in fee, or at least, but partially, they are yet able to drink at the streams. Hence the English jealousy of certain rights which are guaranteed by Parliament. But here in America, and here alone, we have gone at once to the fountain of liberty, and raised the people to their true dignity. Let the lands be possessed by the people in fee simple, and the fountain be kept pure, and the streams will be pure, of course. Our jealousy of trial by jury and the liberty of the press, etc., is totally groundless. Such rights are inseparably connected with the power and dignity of the people which rests on their property. They cannot be abridged. All other nations have wrested property and freedom from barons and tyrants. We begin our empire with full possession of property and all its attending rights. End footnote. The power of entailing estates is more dangerous to liberty and republican government than all the constitutions that can be written on paper or even with a standing army. Let the people have property, and they will have power, a power that will forever be exerted to prevent a restriction of the press, an abolition of trial by jury, or the abridgment of any other privilege. The liberties of America, therefore, and her forms of government stand on the broadest basis. Removed from the fears of a foreign invasion and conquest, they are not exposed to the convulsions that shake other governments, and the principles of freedom are so general and energetic as to exclude the possibility of a change in our republican constitutions. But while property is considered as the basis of the freedom of the American yeomanry, there are other auxiliary supports, among which is the information of the people. In no country is education so general. In no country have the body of the people such a knowledge of the rights of men and the principles of government. This knowledge, joined with a keen sense of liberty and a watchful jealousy, will guard our constitutions and awaken the people to an instantaneous resistance of encroachments. But a principal bulwark of freedom is the right of election. An equal distribution of property is the foundation of a republic, but popular elections form the great barrier which defends it from assault and guards it from the flow and imperceptible approaches of corruption. Americans never resign that right. It is not very material whether your representatives are elected for 1 year or 2, but the right is the Magna Carta of your governments. For this reason, expunge that clause of the new Constitution before mentioned, which gives Congress an influence in the election of their own body. The time, place, and manner of choosing senators or of representatives are of little or no consequence to Congress. The number of members and the time of meeting in Congress are fixed, but the choice should rest solely with the several states. I repeat it, reject the clause with decency, but with unanimity and firmness. Accepting that clause, the Constitution is good. It guarantees the fundamental principles of our several constitutions. It guards our rights, and while it vests extensive powers in Congress, it vests no more than are necessary for our Union. Without powers lodged somewhere in a single body, fully competent to lay and collect equal taxes and duties, to adjust controversies between different states, to silence contending interests, to suppress insurrections, to regulate commerce, to treat with foreign nations, our Confederation is a cobweb liable to be blown asunder by every blast of faction that is raised in the remotest corner of the United States. Every motive that can possibly influence men ever to unite under civil government now urges the unanimous adoption of the new Constitution. But in America, we are urged to it by a singular necessity. By the local situation of the several states, a few command all the advantages of commerce. Those states which have no advantages made equal exertions for independence, loaded themselves with immense debts, and are now utterly unable to discharge them, while their richer neighbors are taxing them for their own benefit merely because they can. I can prove to a demonstration that Connecticut, which has the heaviest internal or state debt in proportion to its number of inhabitants of any in the Union, cannot discharge its debt on any principles of taxation ever yet practiced. Yet the state pays in duties at least $100,000 annually on goods consumed by its own people but imported by New York. This sum, could it be saved to the state by an equal system of revenue, would enable that state gradually to sink its debt. Footnote: the state debt of Connecticut is about $3,500,000. Its proportion of the federal debt about the same sum. The annual interest of the whole, $420,000. End footnote. New Jersey and some other states are in the same situation, except that their debts are not so large in proportion to their wealth and population. The boundaries of the several states were not drawn with a view to independence, and while this country was subject to Great Britain, they produced no commercial or political inconveniences. But the Revolution has placed things on a different footing. The advantages of some states and the disadvantages of others are so great and so materially affect the business and interest of each that nothing but an equalizing system of revenue that shall reduce the advantages to some equitable proportion can prevent a civil war and save the national debt. Such a system of revenue is the sine qua non of public justice and tranquility. It is absurd for a man to oppose the adoption of the Constitution because he thinks some part of it defective or exceptionable. Let every man be at liberty to expunge what he judges to be exceptionable, and not a syllable of the Constitution will survive the scrutiny. A painter, after executing a masterly piece, requested every spectator to draw a pencil over the part that did not please him. But to his surprise, he soon found the whole piece defaced. Let every man examine the most perfect building by his own taste, and like some microscopic critics, condemn the whole for small deviations from the rules of architecture, and not a part of the best constructed fabric would escape. But let any man take a comprehensive view of the whole, and he will be pleased with the general beauty and proportions, and admire the structure. The same remarks apply to the new Constitution. I have no doubt that every member of the late convention has exceptions to some part of the system proposed. Their constituents have the same, and if every objection must be removed before we have a national government, Lord have mercy on us. Perfection is not the lot of humanity. Instead of censuring the small faults of the Constitution, I am astonished that so many clashing interests have been reconciled, and so many sacrifices made to the general interest. The mutual concessions made by the gentlemen of the convention reflect the highest honor on their candor and liberality. At the same time, they prove that their minds were deeply impressed with a conviction that such mutual sacrifices are essential to our union. They must be made sooner or later by every state, or jealousies, local interests, and prejudices will unsheath the sword, and some Caesar or Cromwell will avail himself of our divisions and wade to a throne through streams of blood. It is not our duty as freemen to receive the opinions of any men, however great and respectable, without an examination. But when we reflect that some of the greatest men in America, with the venerable Franklin and the illustrious Washington at their head, some of them the fathers and saviors of their country, men who have labored at the helm during a long and violent tempest, and guided us to the haven of peace, and all of them distinguished for their abilities, their acquaintance with the ancient and modern governments, as well as with the temper, the passions, the interests, and the wishes of the Americans. When we reflect on these circumstances, it is impossible to resist impressions of respect, and we are almost impelled to suspect our own judgments when we call in question any part of the system which they have recommended for adoption. Not having the same means of information, we are more liable to mistake the nature and tendency of particular articles of the Constitution, or the reasons on which they were admitted. Great confidence, therefore, should be reposed in the ability, the zeal, and integrity of that respectable body. But after all, if the Constitution should in its future operation be found defective or inconvenient, 2/3 of both houses of Congress, or the application of 2/3 of the legislatures, may open the door for amendments. Such improvements may then be made as experience shall dictate. Let us then consider the new federal Constitution as it really is, an improvement on the best constitutions that the world ever saw. In the House of Representatives, the people of America have an equal voice and suffrage. The choice of the men is placed in the freemen or electors at large, and the frequency of elections and the responsibility of the members will render them sufficiently dependent on their constituents. The Senate will be composed of older men, and while their regular dismission from office, once in 6 years, will preserve their dependence on their constituents, the duration of their existence will give firmness to their decisions and temper the factions which must necessarily prevail in the other branch. The President of the United States is elective, and what is a capital improvement on the best governments, the mode of choosing him excludes the danger of faction and corruption. As the supreme executive, he is invested with power to enforce the laws of the Union and give energy to the federal government. The Constitution defines the powers of Congress, and every power not expressly delegated to that body remains in the several state legislatures. The sovereignty and the Republican form of government of each state is guaranteed by the Constitution, and the bounds of jurisdiction between the federal and respective state governments are marked with precision. In theory, it has all the energy and freedom of the British and Roman governments without their defects. In short, the privileges of free men are interwoven into the very feelings and habits of the Americans. Liberty stands on the immovable basis of a general distribution of property and diffusion of knowledge, but the Americans must cease to contend, to fear, and to hate before they can realize the benefits of independence and government, or enjoy the blessings which heaven has lavished in rich profusion upon this Western world. This is the end of Section 7, and the end of an examination into the leading principles of the Federal Constitution by Noah Webster.